Thank you, Roxy. I see we already have a question. Regina, you asked if there's a way to see me. Unfortunately, there is not, because we are going to actually use some zip forms today, so I think the forms are going to be a lot more important than you seeing me. I hope that's okay. So thanks for joining us today. We have several forms to go over. This will be the TAR forms, Texas Association of Realtor forms. There were actually 20 forms that changed. There are also going to be some forms that I'm going to try to cover towards the end of the presentation as well that are going to be TREC changes. So I'm going to try to hit both of those as time allows. So with that, I would love to just go ahead and get started. The first form that we're going to look at is the buyer representation form, and that is going to be number 1501. Now these are in your zip forms, so you're fine looking at those. Again, we have lots of forms to go over, so I'm just going to show you the highlighted changes. So let's look at that form. The main change that happened with the buyer rep form was going to be, as you know, when they change forms, a lot of times the main thing they do is just change some verbiage. And on this one, the only difference was paragraph 15. They added persons. So this is the limitation of liability clause. And again, they just changed liable for any person's personal injuries. The only other change they made was fair housing. Fair housing had a change this year, and they added the words sexual orientation or gender identity. So these were added to the fair housing notices in paragraph 18. And then, of course, you still have the broker's printed name, and then, of course, the signature from the broker or the associate. Again, you do not have to sign these. You're welcome to just print them. However, you do have a signature on the buyer rep agreement. So that is all for the buyer rep agreement. Any questions? All right. Moving on to the next form. The next form we are going to look at is the buyer closing cost. You know, there's approximation of buyer's closing cost form, and the reason that they changed that is they wanted to make sure that we understand this is an approximation. So it says approximate, approximate, approximate. That was really the only change that happened, and again, that's form 1936. So again, you just see approximate, approximate, approximate. So hopefully this will give a little bit more clarity to the form. The next one is going to be the inspector information form. They did add buyer or seller. So depending on who you're going to show the form to, you can check one or the other. Before it was simply buyer. That form number is 2506. And that is really the only thing that changed on that particular form. So they just included the buyer and the seller. Removing the contingency. The notice to remove contingency for a sale of other property. That is form number 1912. And the whole change on that is they just added the words in writing. So now when you are waiving the contingency, you need to notify the seller in writing of the waiver and deposit the additional earnest money. So as you can see, a lot of these forms, simply verbiage change. That's really it. The next one is information about special flood hazard. That particular form is 1414. And the main change on that one was going to be on page 3 when it talks about E, the elevation certificate. This is totally new. This is another part that they've added. And this is talking about the elevation certificate, that being very important, determining the flood insurance rates. So again, you're going to need to have that, and that is something that, of course, will be, you can get that from your insurance person, right? But it is something that's going to talk about rates as far as flood insurance cost and things like that. So that's just something that they added.
Lori, we have a question here. What was the form number of the form for sale of other property?
Okay. The form number for the sale of other property was 1912. And that's actually removing the contingency. So form number 1912. Any questions about any of the other forms we've gone over so far? Okay, moving right along. All right, the next one is going to be new condominium complete contract. Now, just to let you know, in almost all of the contracts, they have taken out the satellite systems and equipment. So that has been removed due to the fact that a lot of companies will take their equipment, maybe it's rented. So consequently, we don't have that in the contracts anymore. So you're not going to find that. And typically, it's going to be in paragraph 2 or paragraph 3 of paragraph 2.2 or 2.3. Now on this one, the condominium, the only thing that changed on this is going to be down here. Sorry, I'm going to have to keep scrolling. Okay, it's going to be in paragraph 12 when it talks about settlement and other expenses. They added number 3 and number 4, and this is going to be talking about association dues. This says the buyer will pay any and all association fees or other charges resulting from the transfer of the property not to exceed blank, and the seller will pay the excess. This is very similar to the HOA documents that we get with non-condo. So this is just verbiage that has been added to the condo contract, and it kind of takes the place of that HOA addendum that we see in residential contracts. Also, it says in number 4, the buyer will pay any deposits for reserves required at closing by the association. So this has been added to this particular contract. And that is all. One thing too that I wanted to let you guys know is on the ratification fees on the last page of the contract, we no longer have to sign. Now, it doesn't say anything about that on the condo, but typically you don't have to sign these. You can print your name, and it's totally fine to print versus sign. So that was another change that happened. Okay. The next one we are going to talk about is going to be the condo.
Can you repeat the form number? Maybe if you could go back to the top again and or
sure,
on your list and tell each of them all the form numbers again. We're getting a couple of questions on that.
Certainly, and I apologize if we're moving too fast. On the residential buyer-tenant agreement, the form number is 1501. On the approximate buyer closing cost, the form is 1936. On the inspector information form, the form number is 2506. And then on removing the contingency, the form number is 1912. And then information about flood insurance is 1414. And then the new residential condo complete is going to be 1608. So those are the ones that we've gone over so far. Now we're going to go to the residential condo incomplete construction. And again, pretty much exactly the same thing that you just saw. They have added to paragraph 12. Again, this verbiage that's typically in the HOA addendum that we don't use with condos, so they have added this to the condo contract. And those are really the only changes that we have for the condo contract. Okay, now we're going to go to the farm and ranch. Now these are listing contracts. These are listing contracts. So just to let you know, the farm and ranch had a little bit of change this year. One thing that we noticed was over here, they've added other fees and or reimbursable expenses. So that is going to be something, if you're talking with the seller and you have other fees, then you can list them here, reimbursable expenses, whatever they might be, you can put those in. Then also we had this verbiage as well. This lets you know that the MLS rules may require the information to be submitted to the MLS throughout the time the listing is in effect. So that is just to let you know if you had any holdover. For example, in paragraph C, where it talks about holding it out from the MLS for whatever reason, then you would have to notify the seller and let them know, here's the scoop. The property will not be included in MLS database and therefore unavailable to be seen by agents and brokers. And your property will not be included in the downloads or the syndication sites to various internet websites. So this is a notice. If you're going to hold it off the MLS, then this is put in here. It also says, real estate agents and brokers or members of the public may not be aware of any terms and conditions that you have for marketing the property, so they may not be able to see the property. So that was the big change that they made to the farm and ranch. They also put in paragraph 8, the broker will not disclose the terms of any competing offer unless specifically instructed by the seller, and this is in regards to multiple offers. So this is talked about immediately in the notices. And again, this particular form number is going to be form number 1201. 1201. Now the other thing they did is they actually added the word addendum in paragraph 19 in the notices, where it says addendum for seller disclosure of information on lead-based paint. So instead of it being a notice, it's actually an addendum, and they want to make sure that everyone understands that. Again, we talk about fair housing. So in the additional notices, paragraph 22, we also have that verbiage talking about sexual orientation or gender identity. So that is now part of a protected class and part of fair housing. Again, you have signatures, and that's it for the farm and ranch. Again, form 1201. Form 1201. And these are in your zip forms, so you can look these up. These are ready to use in the zip form. Now, the next one, I don't know if everyone is aware of this, but I wanted to put it in. It's not a TAR form. However, it is a form that Metrotex has created. So I wanted to kind of give you a glimpse of it and when to use it. This is notice to seller regarding instruction to exclude or delay listing from the MLS. Now, we talked about that with the listing. So it says here that you have instructed the broker either to delay or withhold the filing of the property in the MLS, which is totally fine and it's okay to do. However, we just want to make sure that the seller understands what the ramifications are for that. So the first paragraph and the seller initials, each one of them, there's 4. It just talks about, your home is not, here's what the MLS is. It's basically a database, and it opens it up to every ready, willing, and able buyer. You have the option to have it on several internet sites, but it doesn't guarantee a sale, but it does ensure maximum exposure. So that lets you know. And then it says if you hold it off, you may not be exposed, acknowledged that the highest and best offer may not be obtained for your property. It also says that the MLS is a private subscription, so the only people that are really going to have any benefit for seeing it are going to be brokers and appraisers. And the reason for the data is so that we can make sure that we have sold data, so we know when we assist buyers and sellers what to price the property for. And then the final one talks about fair housing, and it just says be sure that you understand that although it may not be your intention, it could be construed that you are excluding certain people from seeing the house. So this is simply an acknowledgement, and it's simply a notice that you can share with your seller should your seller decide to hold it off the market. It covers you and it covers them as well. It's a good risk management tool.
Lori, since this one does not have a form number, can you explain to them where they can find this?
Absolutely. The form number on this actually is 8991. 8991. And you can find that in zip forms. If you look at the all forms on the right-hand side of your zip form screen, if you will go to the libraries and click on Metrotex, it will be in there. It'll be in the Metro text section. So good form to use. Okay, now the residential listing agreement, the 1 to 4 residential listing agreement. Okay, the only changes on that one, there were a few. The main change, again, we have the other fees and or reimbursable fees. Fee simple. So they changed this verbiage to the seller means any transfer of any fee simple interest in the property. So they just added that verbiage to clarify a little bit. And again, under the listing services, we have the same information that we had in the Farm and Ranch. MLS requires that, information be submitted to the MLS in a timely manner. And then over here, if you're going to hold it off, again, they have that verbiage here to let you know and let your seller know here's the pros and cons of that. And then the only other thing they have on that, I believe that's it. The broker will not disclose any terms of competing offers unless specifically instructed by the seller. So those were the changes to the listing agreement. And again, they added that verbiage, addendum for seller disclosure. Again, we did add the fair housing to sexual orientation or gender identity. And that is all we have for the listing agreement. If there are any questions so far, and again, the listing agreement is Form 1101. That's 1101. Okay, now we're going to look at the residential lease agreement, the lease listing agreement. So if you have properties for lease that you're going to list, this one pretty much the same information. Again, we have the MLS rules. We have notice to the landlord about holding it off the market. We also have information regarding the gender, which will come up on that here. Right here in 22B. And then this was added as well, paragraph G. It says the property code requires the property to be equipped with certain types of locks and security devices. Window latches on each window, key doorknob lock or key deadbolt lock on each exterior door, sliding door pin on each exterior sliding glass door, sliding glass door handle, latch or sliding door security bar, keyless deadbolt device, and a door viewer on each exterior door of the dwelling. So the property code also requires smoke alarms in certain locations, and that you are required to test the smoke alarms each time a new tenant occupies the property. So doing a little risk management for you and the landlord who's getting ready to list his property. And that's all the changes on the lease listing. Okay, we're going to go to the lease application. There were some changes on that. And basically, the main change is instead of landlord only, they added or property manager's name. Again, this form is going to be 2003. And I apologize, the one for the lease listing was Form 1102. And again, this form is 2003. Application for lease, the only changes were the property manager's name, as you can see down here. And then this was changed too. I love this. Will any pets, and they have some dogs, cats, birds, reptiles, fish, and other pets, be kept on the property? If so, list all. So I guess they are making that a little bit more definitive regarding what kind of pets you have on the property, whether it's a fish in a fishbowl, reptile in a cage, whatever. What kind of pets do you have? And then also down here in the notices, it asks if you had any credit problems, and they have expounded on this, including any outstanding debt, for example, student loans or medical bills. As you know, most landlords will require a credit report ran, and so this just kind of sets that sets the tone for that if you have any issues. It gives an additional comment section so that they can put down maybe what has happened in their life. If they want to let you know, yes, we've had these issues, then they can do that. Also, fees. The verbiage changed for who you're going to make this out to. So this is an application. It's non-refundable fee of X to blank. And that can be an entity or an individual. So if you're processing through a company, you could write it to the company, you could write it to your brokerage, however you do that, then that will take care of that. And again, that's all there was on the lease agreement. And that again was residential lease application, and that form is 2003. Now we're going to go to the pet agreement. They have added 2 extra spaces for pets. I know you guys are going to love that. Property managers. They have also added this verbiage to the access. So this is talking about you have to remove or confine any pet at any time that the pet is likely to limit or prohibit the landlord or other persons access to the property in its entirety. In its entirety, they've added that. So if you have to get to the backyard, you have to get into the utility room, the bathroom, whatever, then the pets either need to be removed or caged. And that was really all there was on that particular form. Again, that's TAR 2004. The next one is going to be the lease inventory condition form. That particular form is 2006. Again, 2006. The only changes on this particular form were they just added some verbiage to it. Gonna have to get down to it right here. It says this form is not a repair request. I know we're all gonna appreciate that. This is not a repair request. Submit all requests for repairs separately in accordance with your lease. So that just lets them know this is simply a notice of the condition of the property at move-in. It's not asking the landlord to take care of anything or to repair anything. This is simply how it looks right now, today, snapshot in time. So that was the only change on that. And again, that's form TAR 2006. The next one is the residential lease. The residential lease is form 2001. 2001. The only change on that had to do with the automatic renewal and notice of termination. This just lets you know it's going to renew on a month-to-month unless the landlord or the tenant provide the other party written notice of termination as provided in paragraph 4A. And it just lets you know that if no box is checked, they are going to assume it is going to be A1, which is going to be 30 days before the expiration date. Okay? And then if there's no box checked on 4B, then 4B1 is going to be it, and that'll be on the last day of the month. Again, it's going to automatically renew month to month unless you provide a notice. Then the method of payment actually allowed the landlord to either charge or not charge a reasonable fee to process or accept a payment. So, for example, if it was an electronic payment or something that had to have a charge for the landlord, it allows them to give a service fee charge, just like you would have if you used a credit card or something like that. The other change was in the security deposit in paragraph 10. It says any additional deposit the tenant pays to the landlord other than the security deposit will automatically become part of the security deposit. So if there was any additional money paid, it will automatically be lumped in with the security deposit, which also means when they move out, they will get that money back within 30 days. Trip charges. Again, this just lets you know that this could be including but not limited to any occupant, guest, or invitee of the tenant, pet, or security devices prohibiting access to any area of the property. So again, a trip charge could be charged to the tenant, whether a guest would not let him in, whether a pet or even an alarm system would not allow them to come in. So they've added that verbiage as well. And then on paragraph 3, it says the landlord may charge the tenant a trip charge as provided in paragraph 14C. Now, the other change was in property maintenance, and that's paragraph 17. And I know we're going to love this. This says that we can charge the tenant for extermination, including treatment for bed bugs, unless otherwise required by law. That's always reassuring, right? So just to let you know, those were some changes on the tenant or the lease agreement. Now, there is also a change about failure to maintain. Okay, this would be like for pool and spa.
We have a question real quick,
Yes.
Lori. What if it is a non-refundable pet deposit?
If it's a non-refundable pet deposit, then that's going to be handled in the other portion of the lease agreement, and you're going to have that under the pet deposit addendum. So it's either going to be refundable or non-refundable. So that'll be under another addendum. That's your question? Okay. So this just lets you know that if for any reason the landlord had to incur any expense for remedying any kind of issue like with pool maintenance, then they could charge an administrative fee or any other entity as provided by law. So for example, if the city comes out and has to drain the pool, then that could be charged to the tenant. Smoking was changed as well. As we all know, some allow smoking and some don't, and some, will smoke in the garage or any outdoor areas. However, they have added this, including but not limited to the garage or outdoor areas of the property. So either it's permitted there or it's not permitted there. Again, repair request says you can call the landlord or, if applicable, the property manager. So that just gives you an opportunity if you have it property managed. The payment of repair cost, the landlord will pay the repair or remedy the conditions, period, unless it's due to the tenant's negligence. Security devices, again, this is just like earlier when we talked about it. It just says that you will be provided window latches on any window, keyed doorknob locks, keyed deadbolt locks, sliding glass door pin on each exterior glass door, sliding door handle latch or a security bar, and a keyless deadbolt device, and a door viewer on any exterior doors. Again, on the early termination clause, that was changed as well. The tenant is not entitled to early termination due to voluntary or involuntary job or school transfer, changes in marital status, loss of employment, loss of co-tenant, changes in health, purchase of a property, or death. So this just lets you know there is a no easy out clause. They are adding this verbiage so that they understand, regardless of what happens, you need to address this because this is not an opportunity for early termination. Also, they added the term or stalking. It says here, tenants may have special statutory rights to terminate the lease early in certain situations involving family violence, military deployment or transfer, or certain sex offenses or stalking. So they added the or stalking. Again, they added that to paragraph 3. Sex offenses or stalking, they can terminate the lease if it's a sexual offense or stalking, and if the tenant provides the landlord with the documentation required by the property code. So they do have to provide documentation regarding that. This is something too that they've added. Because it is a TAR form, we belong to TAR as a membership, and therefore we have to be an active member in order to utilize these forms. These forms are copyrighted and only TAR members are allowed to do that. So it says here that if an active member of TAR does not negotiate this lease, and it's not done with the assistance of an attorney or lawyer, then it is voidable at will by the tenant. So that means if you have someone who is not a member of TAR and they're not a legal person, then this whole lease agreement could be voidable. And then also,
we have another question
Yes.
before you move on. So you can get out of the lease if you're stocked, but not if you die.
that's a great question. Let's go back to that. It does say or death. So that's interesting. Yes. Apparently, and I'm just going to tell you what the contract says. It says they're not entitled to early termination, whether they purchase a property or death. However, if something happens, yes. The answer is yes. If you're stocked and you have paperwork to back that up, then yes, you can get out of the lease. I think that's interesting. But yes, that is exactly how it reads. All right, paragraph H, talking about the insurance and what it does not cover. Again, this just reiterates that the landlord has insurance on the dwelling, but they do not have insurance on interior property. So the tenant really needs to obtain liability insurance and insurance for casualty, such as fire, flood, water damage, and theft. So again, renter's insurance, very, very important. And it also gives you an opportunity to say if the property is not managed by the above named broker, it will be managed by either the landlord or the property manager. And it gives an opportunity for you to give that information. This was interesting too. This little box at the bottom just lets you know that we've had an issue with people not getting copies of their leases, not getting copies that they need, whether it be the landlord or the tenant. So now it says here that the landlord has provided a copy of the lease signed by all parties to the tenant by whatever venue they go, either mail, email, fax, or in person. And it says the landlord must provide at least one copy of the lease to at least one of the tenants no later than in 3 business days after the lease is signed. So just to let you know, the landlord has to provide a copy. And again, that is the lease agreement. It's TAR form 2001. Okay, now we have extension of the lease. And as you know, there are 2 different types of extension because the lease says something different from earlier forms than the latest form. So if you have a lease that was on a form that was published prior to January 1, 2014, then you need to use one form. And if you have one that's after January 1, 2014, there is another one. Now, this is in zip forms, and you have all 3 of these pages together. So you just need to figure out which one it is. So if you're going to extend the lease, if it's before January 1, 2014, then you need to have the named person in contact, paragraph 34, remains the same, and they've added that or stalking to the special statutory rights. Again, or stalking. And that's the only change to that one. Then if it was after January 1st, 2014, there is no change on that particular one at all. So again, TAR form 2005, you will have 3 pages. It will have the instructions on page 1, and then you'll have a form for before January 2014 and one for after January 2014. Okay, residential lease for multifamily property unit. That is going to be form 2011. Again, form 2011. The only change really was just like the other one, automatic renewal and notice of termination. Again, if you don't check a box, they are going to assume it's going to be box 1, 30 days prior to expiration. And again, it's going to be on the last day of the month. The method of payment, they did allow also that the landlord may charge a reasonable fee or may not. And the other change again was to the security deposit. Any additional deposits will become security deposit. Unless you have the pet deposit with non-refundable, and that'll be on the pet addendum. Trip charges, the landlord can charge them for a trip charge if they do not allow them to come in. Again, trip charge So pretty much just like the other lease. You have the treatment for bed bugs. The difference here is you do have yard maintenance. Now the change to that was the yard, meaning all lawn, shrubbery, bushes, flowers, gardens, trees, rock, or other landscaping, other foliage that encroaches on the property. So either you are responsible or you are not. So either landlord or the tenant will be responsible and also water the yard at reasonable times. And it will be the landlord or landlord's expense will maintain the yard or the tenant will maintain. So you have to decide which one is going to do that. And again, it says here the tenant will maintain and effect a scheduled yard maintenance contract with a contractor or someone else. So if there's something that the landlord or the tenant is setting up, then that just needs to be disclosed. Failure to maintain, again, you can add administrative fees if there are any agents or entities that are going to be giving you a fee or a bill for that. Again, smoking included but not limited to garage or outdoor areas. And again, the tenant may call the landlord or the property manager at this particular number, so they've added that. Payment of repair, again, landlord needs to take care of that. You need to be an active realtor and member of TAR in order to use these forms, or a lawyer. If someone else is using these forms, then it could be voidable. Liability and insurance, again, landlord's broker will or will not act as property manager. So this verbiage, just like the other lease, and again, no later than 3 business days. So that was the multifamily lease, and that was TAR 2011. TAR 2011. Now we're going to look at the residential property manager agreement. That is going to be Form 2201. Again, 2201. The main change on this one was it just allows the owner, if they're not an individual, then they have an other spot, okay, which was created. So that just gives them an opportunity to say who owns it. It could be an entity as opposed to an individual. And then this particular one talks about fees upon termination. It says the owner must pay the broker amount specified in paragraph 12. So let's look at paragraph 12. Okay, so paragraph 12 talks about fees upon termination. So if you terminate prior to, then all fees are due to the broker under this agreement, and if the property is leased, then and the owner terminates, then there will be an amount equal to the lesser of either the management fees that would have accrued over the remainder of the lease, or blank, a flat fee. So this is something that you would need to fill out and arrange for in case of early termination. Now, the other portion that they added to liability and indemnification is paragraph A. They added failure to properly water the foundation of the property. As you know, if you do not water in Texas, then we have foundation issues. And so consequently, when the manager is property managing the property, they need to make sure either the landlord or the tenant one is watering the property. So somebody needs to water, but it says the broker's not responsible for watering. So that would be up to the landlord or the tenant. It also says broker is not responsible and liable for other things. The only other addition, again, the copyright. So that was put in there, again, about these are copyrighted forms, and no one that is not a member should have these forms nor use them. The fair housing was added as well to talk about gender identity or sexual orientation. And that was all for that particular form. And again, that's Form TAR 2201, and that is the property management form. Property management form. Okay, we're moving right along, folks. That's good. Okay, addendum and authorization to act for an owner before homeowner association. This particular form is 2205, Form 2205, And basically, it's where an owner is going to grant a broker opportunity to stand before the HOA. And they added this verbiage, except as expressly provided, this addendum does not obligate the broker to attend association meetings. So this allows the broker to act for the owner in his stead. However, you're not required, broker, to attend all the meetings. And again, this is TAR form 2205. The next form is going to be notice terminating the right of occupancy. That particular form is 2208. And the only change that they added is they added regular mail. So the landlord can terminate the tenant's right to occupy the property via effective date, so many days after the date of this notice is delivered, by certified mail, return receipt, or just regular mail. So they have added that as well. And they put regular mail down here as well. So that's form 2208. Okay. Notice to tenant of change in management and accountability for the security deposit. If you are selling a property that has a tenant in it and you are selling it, it has a lease in place, you must deliver this to the new tenant. What this does is it lets you know, guess what, we have sold the property, and consequently the following person is now, or company is now responsible for the property. The person you should direct any questions to about your security deposit or any other obligations under the lease, and the person that you should make your future rent payments to. So if you are changing hands and you're going to use property manager, you would put that down. If you're going to let the owner take care of it, whatever. And so this would be signed by the prior owner, and it would have a printed name and what they are, capacity they are, whether they're the new broker manager, the previous broker, new owner, or the old owner. Okay? And that is TAR form 2210. 2210. Okay, now we are done with the TAR forms. Whew. That was quick. All right, so Roxy asked if I would go over some of the TREC forms because those are changing. Now, they will be mandatory use as of June 1st. As of June 1st. And they are currently not in zip forms, just to let you know. They are not in zip form yet, but you can go to the TREC website and download them for use. So they are on the TREC website. So I wanted to just go over some things that are on the forms. To let you know, it's going to be the 1 to 4 family residential, the new home complete, new home incomplete, the condo, the farm and ranch, unimproved property. Then we had a change in the third-party financing, which we are currently using, and we had a new addendum on the propane gas, which I'm going to show you as well. Just to let you know, on all of the contracts, again, they have removed the satellite information. So they have taken any satellite and satellite equipment out, and typically that would have been in the improvements accessories area. They've removed that verbiage just because some of them are leased, like we talked about earlier, and so they may take them, they may not. So just...
we have a quick question. Where can we find red line versions of TAR forms to share with associates?
You know, I looked on there to see if we had the red line, and I believe that they are off the website currently. But I am happy to give you these that are highlighted if you would like a copy of those. Just contact Roxy, and we are more than happy to share these. And these are the actual red-lined changes. So I have just highlighted, so it is exactly off of the website.
We can email those to everybody, so y'all don't need to. We'll just send those out after the webinar. Within the next 2 days, you'll get a copy of it.
Absolutely. All right, on the forms for the contracts, there are certain things on all the contracts that you're going to see over and over again. Most of them are going to have in the financing, not for use with reverse mortgage financing. Now, there is a new form that they are looking at that is going to be coming up at a later date, and that will be the reverse mortgage financing addendum. It will be available for use June 1st, but we do not have it currently. The other change was paragraph 8 in the title policy, or I'm sorry, number 8 in title policy and survey. That's paragraph 6 of the contract. The changes here really are talking about that they are going to add a exception or get additional insurance for shortages in boundary line encroachments or protrusions. Typically, that is not included. So it says it will be amended or deleted, or it will be amended to read that it is covered. And if it's covered, who's going to pay for it? The buyer or the seller? So this just gives you an opportunity to get it or not get it. And if so, if you get it, who will pay for it? This particular one is going to be the 1 to 4 family residential contract, and the TREC number is 20-12. 20-12. The other thing that changed is on the commitment, paragraph B. It says within 20 days, title company receives a copy, then they'll furnish a title commitment. Now down here, they have made the days, they've added the 3 days before closing. It used to just say or before or on by closing. So they've added 3 days, so that's going to give everyone a little bit of room to breathe so we can get it and we don't have to rush to the closing table unbeknownst to us what's on there. So they've added that. The other change is going to be in the notices, and this is going to be number 9, propane gas service system service area. This is a new addendum. We're going to look at this too towards the end. This is an addendum that if your property is located in a propane gas system service area owned by a distribution system retailer, then the seller has to give notice as required by the Texas Utilities Code. And an addendum should be used with this. So if you are in a place that provides propane gas and you have to purchase it through this retailer, there are certain rules and regulations with that. I won't go into it. I'll show it to you on the addendum, and that'll be the last thing. Paragraph 7, I know we're all excited about this. 7D1 says buyer accepts the property as is. As is. So again, this just lets them know it is as is. And that's going to help for those of us who do short sales for the bank. But this also lets you know this does not preclude the buyer from inspecting the property or negotiating repairs or treatments. So understand you still have that option during the option period. The completion of repairs, that was changed as well to say that they must be performed by persons who are licensed, or if no license is required, like roofers, then someone who commercially engaged in the trade of providing that repair or treatments. And they extended the close date up to 5 days if for any reason the repairs are not done prior to closing. The other change was leases. This used to be in paragraph 9, and they moved it to paragraph 10 on possession. And it just says basically, after the effective date, the seller is not allowed to execute any lease, including but not limited to mineral, or convey any interest of the property without the buyer's written consent. It says if there's a lease on the property, then the seller has to provide those copies within 7 days after the effective date of the contract. I love this paragraph. I think it's awesome. So if you have a lease in place, understand, listing agents, you need to get that to the buyer's agents within 7 days after the effective day of the contract. Another change was some verbiage added. The seller shall restore the property to its previous condition as soon as reasonably possible, but in any event before the closing date. This is going to be paragraph 14, the casualty loss. So just to let you know, the mediation clause changed, paragraph 16. Again, we do not have those boxes, we will or will not. So it is just going to be assumed that we will mediate. It also has in this verbiage, this paragraph does not preclude a party from seeking equitable relief from a court or competent jurisdiction. So they can still go to court, but it just says we're going to mediate first. The only other changes is they added the addendum for property propane gas service. And the great news is the termination option, paragraph 23. We now have 3 days. I love that. 3 calendar days to get the option money to the seller or listing agent. And the only other change is printed names only do not sign on this broker ratification. That's all there was on that. Now, I will tell you we're pressed for time. However, the other contracts, it is pretty much the same thing on all the other contracts that we looked at. Again, Roxy, we're going to have a TAR.
We'll have a TREC.
TREC. We will have a TREC webinar as well that are going to go over the TREC forms. I just kind of wanted to show you some of those just to kind of let you see them. I do want to show you these two last forms. The third-party financing, for those of you who don't know, this is TREC form 40-6. 40-6. Okay. They have added the USDA financing option. Now, this is in zip forms. This is being used now, but I just want to let you know they did add the USDA.
Lori, we have one more comment, and we do need to clarify this.
Yes.
Someone says, so the 3-day option fee delivery change does not take effect until June 1st.
The contracts are mandatory as of June 1st. Now, with that, I'm going to say you can use the form now. You can get it off of TREC, but what I want you to understand is there are going to be 2 different forms out there currently if you use the new form. So you need to make sure you understand which form you're using, and the listing agent needs to understand which form you're using as well. Because if you do the 3-day and you don't use the correct form, then you could put your buyer in jeopardy because you have not delivered in a timely fashion. So just understand which form you can use. It's available now, so you can use it, but I would just, if you're going to use that form, I would let the listing agent know, hey, I'm using the new form, and we have a 3-day delivery on the option. Hope that answered your question. But June 1, everyone will use them. The last form that I wanted to go over, because this is pretty important, is the addendum for property in a propane gas service area. So this notice is, it is a TREC form 47-0, again 47-0, and it basically says you're about to purchase a property in an area that's authorized by law to provide propane gas service. Because of that, there may be special costs or charges you may be required to pay before you can receive the service. You may be required to construct lines or other facilities necessary to provide that service. So you need to contact the distribution system retailer to determine that cost. And here it says the buyer has acknowledged the receipt of this notice at or before execution of a binding contract for the purchase of the above referenced property. It says a copy of the recorded notice is attached, and you can obtain that from the county clerk's office. So understand, this is not like, just a mud thing or anything like that. This is actual part of the recorded documents. So you will find that in the county clerk's office. So I hope this was informative for you. I hope that I answered all your questions. If you have any more questions, feel free to email Roxy and we will get together and get those questions answered for you. Thank you so much for your time.